Hello guys, I'm Sudarshan, a Starshine Star, and I'm so glad that you're here with me on this beautiful Friday. It is June 27th, 2025, and what a rocking month it has been. It's not over with yet. Hang in there, guys. Every Friday is Mahalakshmi Day, which is an aspect of Mother Divine that pours down upon us not only 100% success in the material things, but 100% success in the spiritual things. And we need both. We need what I call the 200% life. So I have a very interesting, very interesting reading for all of you today. But I begin all of my clips with the 3 opening prayers, which are in Sanskrit and Telugu, and they are short. And I do this to bless, uplift, purify, and protect you, me, and this clip. They are the Guru Mantra, the Ganesha Mantra, and the Gayatri Mantra. Om, 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 Guru Brahma, Guru Vishnu, Guru Devo Maheshwaraha, Guru Sakshat Parabrahmam Tasmahi Sri Guruve Namaha. Om Suklam Bharataram Vishnum Sishivarnam Chatupujam Prasanavaranam Dhyaye Sarva Vignupashantaye. Om Bhurabhuva Swaha Tatsavitur Varinyam Bhako Devasya Dhimahi Dhiyo Yo Naha Prachotayat. Om Shanti, Shanti, Shanti. Wonderful. Well, I haven't quite decided what I'm going to call this clip yet. And I'm even going to decide while I'm reading it if I'll break it up into 2 parts or not. But the title will have something in the title about being wicked smart. This is from the excellent Robert, and I don't know how to pronounce his last name, Gouveia Esquire. He has a channel on YouTube, and this is from yesterday, from June 26th. I like so many things that have occurred over these many last years. Haven't we had to educate ourselves on topics that maybe previously, let's say pre-2019, we weren't even interested in, really? I know I have. It's pretty amazing. And this is an excellent, I think it's something so excellent to listen to in regards to how President Trump's DOJ just sued the entire court of the corrupt Maryland district judges. You know, if you've been looking at this and seeing, it's just ridiculous how President Trump is attempting to be blocked by almost every bloody thing that he does by district courts that are assuming that they have veto power over the executive of this United States of America, and they do not. They're the judiciary, not the executive. But if you want to be wicked smart, or at least approach being wicked smart, I would say listen to this, because I think it's so enjoyable and really amazing to listen to more details about this, so that we only really know a subject when we can teach others about it or discuss it. And I think it's so valuable in this time when far too many beings just believe that their opinion holds much more weight than reality, truth, or facts. Here we go. So this is Robert Gouveia speaking. Trump strikes back, files a lawsuit against the entire district court that includes a bunch of other judges, not just one judge. This is unusual. We don't see a lot of that here on this channel or in this country, really. We have this happening where the United States of America, Homeland Security, are coming in as plaintiffs, and they're suing all the judges: Chief Judge George Russell, Abelson, Bennett, Lake, Boardman, Bredner, something, it sounds like he says Ches Tanal. I really don't know if I'm mispronouncing that. Theodore Tungang, and we've covered cases from him that have been adverse to Trump. Gallagher, Grigsby, Hollander, Herson, Maddox, Rubin, Zenas, who was handling the Kilmar Abrego Garcia civil case, not the criminal case, all being sued, including the clerk of the court and the United States District Court for the District of Maryland. Dang, son, Robert says, all getting sued. So we'll see what happens here and what the judges do, because they're now defendants in this case. And something else that's interesting here, just procedurally and tactically, is now that they're sued, Trump also submitted this. Guess what? You're defendants in a lawsuit. So since we're suing you, you can't judge our cases anymore. So you must recuse yourself under the rules. All of you get off our cases right now. Saying, here also, so we'll come back to the original filing, but this is the motion for recusal. They say, since we're suing all of you, now get off the case and send these to another district. Plaintiffs, the United States of America and Homeland, now respectfully request that each judge of this court recuse himself or herself from this matter. And then Robert says, and Zenas might be a themselves, I don't know. Robert makes me laugh. Okay, back to this. Plaintiff also requests that this matter be referred to the Fourth Circuit's clerk office for reassignment of a randomly selected district judge from another district, or transfer all the cases to another district. So get off. Since we're here, now first, because this court and judges are now named defendants because we're suing you, each judge in Maryland is required to recuse themselves from this matter. A judge shall, under the rules, disqualify himself from a case in which he is a party to the proceeding. We're citing the guide to the judiciary policy. It's your own policy. Even we are not above the policy, Judge. Pack your bags. Policy says, when all sitting judges of a court are named as defendants in a civil action, each defendant judge is ordinarily required to recuse from hearing the case under the canons of judicial conduct. Judges have accordingly recused in similar cases, and so you need to do that now. Saying, recusal is also warranted under the more general standard under a different provision of the law, which says, actually, you should recuse yourself of any proceeding in which your impartiality might reasonably be questioned, including like when your wife and daughter are Democrat affiliated and adjacent entities. Saying, here's an objective inquiry that would lead a reasonable observer to say these judges are biased and should recuse, since they're now being sued. And second, our request that the clerk contact another court is to facilitate a judge who can actually hear this case. Specifically, in these circumstances, the Fourth Circuit explains how we do this. We just follow this rule in different district court. They then contact randomly selected judges, and they serve and recuse. Oh, pretty common. Once such a judge has agreed to preside, then the JSO nominates the chair. And then they transfer certain civil cases, transferred out of there. And there was a conflict, like with the current judges. So they just moved it. And so accordingly, we, Trump, respectfully request that all judges in Maryland recuse themselves. Get off the case. Plaintiffs also request that the matter be referred to the Fourth Circuit's clerk for assignment and transferred to a better judge, duly selected in a different district. And so get your cardboard boxes, judges, and take those cases off your desks. So what you can see is that's just part one. Now they also submitted this in a much broader filing. They say, we are suing you, excuse me, and this is what we want. So while this is pending, you guys have to recuse yourself from our cases, this case, and now we are asking for more, writing, plaintiffs, the United States and Homeland Security and America, through Trump, bring this action for declaration and injunction. We want the court to force them to do or not to do something. They write, all right, Judge, in the District of Maryland, but these judges cannot hear it, right? So this case should be heard by some other judges because they're defendants. And so we're sending it to Maryland, but the judge should contact another judge and have them hear the case and reassign it. It's all by operation of law. Then I think you might argue that in the other cases, right, just to be clear on this, that the Kilmar cases and like the cases that Judge Zenas is on, you'd file, which we might expect to see a motion to recuse from that case. So we haven't seen that yet. But I would expect to see, Judge, up, we're suing you. You're sued, get off the case. Since the same thing happening probably in Chung's case, get off the case. They're suing, you're presiding over the case, but since you're a defendant now and we're suing you, you've got to go. So here's what they write. All right, several hundred years of history in court, new judge. They teach that injunctive relief is an extraordinary, equitable remedy that is never awarded as of right. Okay, if to force somebody to do something, issue an injunction, you have to do this or you can't do this, right? That's like a mandate to a person's personal activity. That's a big deal. You can't just do it willy-nilly. Is an extraordinary equitable remedy whereby you're trying to balance the scales of things and it's never awarded as a matter of right. You don't just come in here and say, I like an injunction. Oh, sure. Here you go. Even when a plaintiff claims that there is going to be irreparable harm. Okay, it's a high standard, in other words. And injunctions against the executive branch are particularly extraordinary, extra high because they interfere with that democratically accountable branch of their constitutional powers. Okay, if you're going to stop the president from doing something, there are mechanisms built into the Constitution and into our society to do that already. You can impeach the president if there's a popular uprising. If people are mad that Trump's deporting all these illegal invaders from our own country, well, they can just complain to the representatives, the ones who aren't representing illegal aliens, and then they can join the ones who are representing illegal aliens, and they can have a majority and impeach and remove the president if it's so egregious, but it's not. And so what they have to do is take a different avenue and use injunctions to exercise powers that they do not have. It is a usurpation of our power, our right, and our structure of governance. Saying, here, the core attitude, two powers to enforce the nation's immigration laws and shape and manage its relationships are all being usurped. Despite these elementary principles, what these judges in Maryland can't figure out. Excuse me. In recent months and years, district courts, especially Zenas, have used and abused their equitable powers to interfere with the executive branch in an unprecedented degree in the first 100 days of President Trump's current term. District courts have entered more nationwide injunctions than in the 100 years from 1900 to 2000. Oh my goodness, requiring the Supreme Court to intervene again and again in recent weeks. And they're getting scolded for being so pathetic and hands-off on this. To pause the unlawful restraint of our Article 2 powers. Now, this lawsuit against these judges involves yet another regrettable example of the unlawful use of equitable powers, which are these injunctive powers. To restrain the executive, specifically, injunctions are a remedy in equity. So when they say equitable powers, they're talking about the court being able to force or prevent somebody from doing something. Specifically, defendants, the judges, have instituted an avowedly automatic injunction against the federal government for basically anything issued outside the context of any particular case or controversy. And they did so by promulgating a standing order. We covered this some time ago. And an amended standing order that required the clerk to automatically enter an injunction against removing, changing the legal status of any alien detained in Maryland who files a habeas petition. Right. So the judge basically set in a new policy, like an email autoresponder, essentially so. Someone files a lawsuit and an illegal alien gets rounded up by Tom Holman. And he's like, you're going home, no more pupusas here. So they put him on an airplane, or about to. They file a motion for a habeas petition. Illegal alien says, no, don't take me out. ACLU gangbang lawyers come crashing their clown cars right into the front door and then represent them. And once that habeas is filed, then the judge has said, you know what? I'm not even going to look at it as soon as it comes in. Like you file it with the court, the paperwork goes out electronically, that gets submitted. Then what you'll see is the judge sets up like an AI chat GPT or whatever. They just automatically say, oh, that's a great petition. We love illegals here. You're an illegal? Habeas granted. Issues an injunction, so automatically it just comes right back. The clerk is directed without reviewing the case. The clerk's not a judge. The clerk doesn't get to say whether it's a valid petition or not, or whether there's good cause to issue an injunction. It's not automatic. Trump has the presumption of fair operation and good dealing to deport these people, as has been the tradition since forever, until Trump came into power. So automatically, just email autoresponder goes out. Actually, you're injuncted. What? They say, you can't do that. You're the judge. Now, the challenged orders here do precisely what the Supreme Court has forbidden. You can't do this. They are making equitable relief an injunction as a matter of right. Soon as an illegal files it, injunction granted. Free injunctions for illegals. You would never get an injunction if you say, the governor is shutting down my business now for COVID, and they say, I have no right to my own private physical property. I can't open my doors and enter private contracts with other people who want to come in and get their private haircuts, for example. You have to be locked down for that. You go to a judge and you say, Judge, I'm a citizen. I've got rights in this country. And they say, get out of my courtroom. You're going to KIL, everyone in here, and throw you out. But if you're an illegal and you're being processed by the federal government and you're following orders of the executive branch, which were these governor executive orders, then you're free not to go. Then you're free not to go. They're going to keep you right here in this country where you shouldn't be. So defendants' automatic injunction from these lunatic judges issues whether or not the alien needs or even seeks emergency relief, whether or not the court even has jurisdiction over the alien's claims, like they didn't even look at it, they file it, right? No matter how frivolous their claims may be, it's automatic. And it does so in the immigration context, and thus it is intruding on core Article 2 powers under the law. The automatic injunction is motivated by the judge's, quote, frustration, end quote, their word in quotes, not ours, with hearings related to the immigration enforcement actions, and a desire to avoid handling cases outside the regular business hours. He's like, these illegals keep filing like at 2 a.m. in the morning. Trump puts them on an airplane at 2 in the morning. Their gangbang lawyers file a bunch of documents. 2:15 a.m. Judges go, ugh. Planes taking off at 2:30. They've got to issue an injunction. Get out of bed and do their job. And they don't want to do that anymore. So they just set up an autoresponder and they say, that's too bad. But a sense of frustration and a desire to greater convenience does not give them license to flout the law, judges, nor does their status within the judicial branch. Just because they're little dictators up there doesn't mean we've got to deal with it, the rest of the country, or accept it as the DOJ. And so judges' standing orders defy the requirements for issuing an injunction. There are rules that you have to go through before you grant an injunction. You can't just automatically do it. They violate congressional limits on the district court's jurisdiction over immigration, and you can't even hear these cases. You're in Article 3 court. Immigration courts are Article 2. Always been that way. Since you know, modern era, and they disregard the procedural Excuse me, I read that a little incorrectly. After always been that way, it's referring to since the modern era that the courts have always been that way regarding Article 2 and Article 3 courts. Okay, and they disregard the procedural and substantive requirements for issuing what amounts to a local rule. They are also fundamentally inconsistent with the judicial rule only to accept cases and controversies, and they're predetermining a case without even looking at the documents. They're essentially presumed, quote, valid, end quote, when that is not the law. Now, in particular, the district courts lack jurisdiction to hear challenges arising from removal proceedings or even issuing orders to enjoin or restrain the execution of those removals. Congress has expressly and intentionally channeled challenges to remove proceedings to specific court process in the Court of Appeals and impose various other bars on judicial review. So these judges are meddling in cases they have no power to meddle in. Their automatic injunction extends relief as of right that district courts lack jurisdiction to issue. Okay, they're seizing power, granting benefits to illegal alien invaders. Now they're getting sued. Every unlawful order entered by the district court robs the executive branch of its most scarce resource, time to put policies into effect. They're stealing our term in the process. Such orders diminish the votes of the citizens who elected the head of the executive branch. Oh, that's us. Yeah, the citizens of the country. Defendants, the judges, lawless standing orders are nothing more than a particularly egregious example of judicial overreach. And I want to interrupt this reading to say, by the way, it's so ridiculous for anyone every time, and the corrupt mainstream media keeps putting this in here, talking about due process and constitutional rights of illegal alien invaders. Our Constitution is for American citizens only. It doesn't apply to everyone who's ever created on Earth. It applies to American citizens. If you're an illegal alien invader, you do not have protected American constitutional rights. Sorry, dream on. You don't have it. Back to this reading. Interfering with the executive branch and undermining the democratic process. They're not elected judges. They're not accountable to the people in any way. You could say, okay, maybe through impeachment proceedings, and I would agree with you, and we should have Congress start opening these impeachment proceedings. We've been advocating for that for a long time. Start throwing that power around. Where has that been? Why are they tolerating this? Why don't they get rid of these circuits if they want to? Plaintiffs are entitled to prompt relief from defendants' unlawful and anti-democratic orders. And so we're suing all these judges. Russell and Abeson, and you know the rest of them, saying, they're a judge of Maryland and they're all there. Same thing for all the judges, all getting sued. Here's what happened. Now on May 21st, not long ago, the judges, they came out with this new standing order. They said illegal aliens are better than everyone. And so we're going to give them special privileges. Not only due process, but due process plus. Due process premium version of America because they're better than you. The standing order applied to all cases filed on or after 5 p.m. It purported to invoke the, quote, All Writs Act and a limited judicial power to preserve our jurisdiction and maintain the status quo. This is why we can do it, because we want to. The standing order also provided that as soon as they file a writ, they are enjoined and restrained from doing anything. You cannot alter their status. As soon as they file it, right? It's granted. What? The standing order provided that an order to this effect shall be entered in every case when it's filing as soon as the dock hits. Email autoresponder goes out. The standing order provided that its term shall remain in effect until 4 p.m., and there's like an end cap on this so that we can essentially get the case and, review it and those things. The standing order directed the docket, the clerk, to docket the standing order in each relevant case. Okay, so in other words, the clerk gets to decide, a petition came in, it's valid. Injunction granted automatically. at least a small injunction. Judge realizes he can't, just automatically grant a permanent injunction. So just a little bit one. And then he'll come back and he'll fix it later. No, you can't do that. And you're going to let your clerk make that decision? If you want to get your butt out of bed, Judge, and make this discretionary decision yourself, you can do that. But you've got to look at it, not her. The standing order stated that it was promulgated to preserve existing conditions and to ensure that they can participate and they don't get afuera out of here. Robert says a lot in his things. He made up a word called afuera. Afuera is a Spanish word like outside, and he's saying like he's making it up like that you don't get made to leave, so he's calling it afuera. So they can participate and they don't get afuera out of here. So on May 28th, they amended the standing order and it was signed again by the chief judge. No effective date on that one. And it says that after filing a petition, you must also give everybody a copy of the order and you cannot remove them. Then we can challenge it later, reviewing what the order says. Now this is causing a big problem on federal immigration enforcement. Explaining from Trump's perspective, says, we're suing the judges now. Trump sued the entire district in this case. He says, the primary mission of ICE is to promote homeland security. Now, before it was to facilitate cartel invaders into our country. Detention is an important part of an alien may enter and exit ICE custody on more than one time. And when you implement these orders, it really impacts our capability to do our job. We have a lack of bed space in Maryland, too. So when we transport them, we capture them in Maryland, we've got to send them out. Now, the orders do not afford our terms any opportunity to contest their assertion. We're going to pick them up from Maryland, send them to Texas. They're going to be housed there. They can file their habeas petitions there. They said, nope, can't move them out of here. Moreover, the orders invite aliens to say that they were in Maryland at the time. So they're exploiting this. This problem has already materialized, making U.S. transfer people around. And it's causing a bunch of problems, adversely impacting the operational planning necessary to move these people around. And also aliens are traveling with fake documents and expiration dates. And you're saying we can't move them around? The order bars ICE from implementing final orders of removal by removing the alien. We've got court orders and you say we can't do it? What? The order even bars immigration judges in a separate provision, in a separate article, and basically entity, from proceeding in the immigration proceedings, including by issuing a separate removal. He's taking the immigration judge's jurisdiction away from them. Says, the order may also bar courts of appeals from acting, and more, so overbroad, it bars the alien from receiving other immigration benefits that would change their status, like even benefits to them. And it's already been entered in multiple cases, disrupting our immigration operation and more. And we face barriers in seeking review because everything is being stalled. Piecemeal appeals of cases are entered similarly. It's not a sufficient opportunity for us to take these up on appeal. So now we're suing you. Here's our claims for relief. You're violating the law, all of you judges. Courts have long recognized that even absent a statutory cause of action, the United States can sue. And guess what? That's what we're doing. Standing orders are only permissible if they're consistent with federal law. You can't just change the law on injunctions by executive order and fiat. Courts must also consider the four-factor test by the Supreme Court before issuing TROs. And you did not do that. Supreme Court has explicitly said you have to follow certain rules, and you're not doing that. Now the orders purport to issue ex parte right. Trump doesn't even have a say in it. They filed their petition. Illegal aliens do not have rights that are afforded to actual American citizens under our Constitution. Period. I'm saying that. Period. Period. Exclamation point. End of story. The overdue process is getting transported out of this country. Deported. It's the due process. And then I'm saying finito. And here's what I want to say in here. This is my side note in interrupting Robert's speaking. You know, if you enter illegally into India, you get automatically 8 years, 8 years in prison in an Indian prison. Can you imagine that? In Pakistan, if you enter illegally, you get automatically 10 years in a Pakistani prison. Okay? There's no ifs, ands, or buts about it. Russia gives several years of hard labor camps. That's the sentence you get if you illegally enter into Russia. So it's just because America, my country, has been ruled by a criminal satanic pedo cartel for quite a while now. And illegals were not only allowed, they were actually flown in under JoJo's administration by Democrats because they needed their illegal votes in order to keep their criminal self-serving grift going. It's just a pure mafia structure. That's all that it is. It's just pure mafia. Not even mentioning all the outright ridiculous chicanery and thieving that has been going on in giving illegal alien invaders so much money, so many rights, so much healthcare, so much free education, free college and tuition, free rent, free housing, free no-interest mortgages in California. So many things that Americans can't even dream of asking for. It's got to stop. And it will stop. Okay, now, so back to Robert's speaking. He's saying, DOJ has no say. The judge just says, you win, injunction. It's really a TRO, but it's, basically an injunction without meeting any of those requirements. They do not require any specific showing of any of the things in the test. Irreparable harms, there's no affidavit or verified complaint. They don't require a written certification. They didn't provide any quote, why, end quote, notice issues are not problematic or are problematic. The orders do not satisfy any of the descriptions the court has to provide showing why there is immediate and irreparable injury. Now, if the orders were instead understood to direct the entry of a preliminary injunction, which, you could argue they would also be unlawful. They may only be issued on notice to the adverse party, and generally the sequence, as we've talked about, right? You get a TRO, it's very temporary, to stop the imminency. Then you prep for further briefing. Then you come back and argue the preliminary injunction. But essentially judges are treating them, they're causing the same outcomes, which are permanent stops to Trump's efforts. So you can call it whatever you want, but they're ultimately just stopping Trump. Now they must be supported by statements of reasons for the injunction. They're not giving them any reasons. They're also violating jurisdictional bars, these judges. Congress has stripped federal courts of jurisdiction to hear any claims based on removal. That jurisdiction gives over to the Article 2 courts. This section is known as the Zipper Clause. It channels all review of any actions taken or proceedings brought to remove the alien from the United States. Under subchapter 2 of the INA into a petition of review that's filed in habeas in their location of confinement. Another provision also bars judicial review of these decisions. Habeas is the only way they can do it. But despite all these restrictions, the judge says, actually, I'm the president now. Expressly stops us from removing these people, plainly exceeding the scope of their powers. So we also say they're violating their own local rules, for crying out loud. Courts will write their own local rules. And they say that local rules may only be adopted via notice and comment rulemaking. And the fact that you issued a standing order on all cases, you can't even issue a standing order unless you go through the due process of issuing a standing order. The judges didn't do it. Judges gave nobody else due process. Trump administration didn't get any due process. The American people who elected Trump, this administration, to effectuate these removals, we didn't get any due process. And the court, when they're issuing their orders, don't even provide due process according to their own rules. But the illegals get everything they want. And now they're being sued. So we're excited to see what happens in response to this. And we're expecting to see other motions of recusals in the other cases, perhaps the Kilmar case in front of Zenas and more. But Tom Homan was saying, excuse me for one moment. Tom Homan was saying, this is Tom Homan, he was on Fox, he said, look, we're going to continue to remove these people. These judges are trying to injunction us to DEATH. But as soon as we get this big, beautiful bill done, we're going to remove these national security threats. We're going to do it with Hayes. Tom Homan on what's coming next. And here he is again on Fox. We've got a lot of, Tom speaking, we've got a lot of work to do. You're exactly right. Which again, I won't just jump right in. We need a big, beautiful bill. We need the funding for more agents. We need the funding for more beds. We need the funding for more transportation. We need the funding for more targeting. So it's imperative, especially right now. So for those on the Hill, I don't care. Removing national security threats, removing public safety threats from this country should be a nonpartisan issue. So get it done. We need the funds to get this done. Well, the good thing is we've got President Trump in the Oval Office. And I can tell you right after the election, we didn't wait until January. We didn't wait for the inauguration. Right after the election, I got together a lot of smart folk to say, okay, we've got a big problem. We're going to deal with it right after the inauguration on 2 million plus gotaways and all these special interest aliens that were released into the United States. So we started planning for this months ago. So day one, the administration, we're hitting the ground. That's why President Trump from day one said, we're going to concentrate on national security threats and public safety threats. That's what we're doing. After the Iran issue this weekend, we just stepped on the gas, adding a lot more resources to it, really hammering it. So we're on it. We're going to do it. We're going to do the best we can as fast as we can. And then back to Robert. He says, all right, Tom Homan explaining judges can try what they're trying to do, but we're going to stay after it and do the mission that we were sent here to do. So we're excited about that. We're going to keep our eye on this case. We're going to see what the Trump DOJ does in this jurisdiction and others. Maybe we'll see the same lawsuit filed in the District of Columbia. Woo! Okay, I hope you enjoyed that. I know it's a lot, but really, I think it's so good to know really what's going on in detail, even if you're not a lawyer and you haven't studied the law. Instead of just going, well, it's just that way because it is. I mean, it's good to have this stuff to point to help other people learn and to gather information, right? Thank you. Please remember to like, share, and subscribe and hit the notification bell. Why not join my YouTube channel? It's called It's the Dazzling of the Light. Or just go to at Sudarshana Starshine Star on YouTube. I have, 230 something or more clips there on a variety of topics. Pretty juicy and hot stuff because I don't do the boring stuff like talk about what I ate for breakfast. I will not do that unless maybe one day I will, but I'm not doing it right now. So thank you so much for being here with me. I end all of my clips with a closing prayer in Sanskrit and Telugu. And what I'm saying is, God bless all beings in all worlds. Om Loka Samasta Sukhino Bhavantu. Loka Samasta Sukhino Bhavantu. Loka Samasta Sukhino Bhavantu. Om Shanti Shanti Shanti. Yes, peace, peace, peace. God bless you and yours. I'm sending much love and big hugs to you and yours. Take care of yourself. Stay safe. Be well. Be positive. I'll see you when I see you. And bye-bye for now.